Hi, everyone. Welcome to our Prepare to Care series. My name is Ariel Green, and I'm the Caregiver Support and Education Specialist for Care Partners. And we are so happy that you can join us today for our second workshop in this series. And so today we have Angela Odensky, who will be speaking on essential estate planning. But before we jump into our presentation, I wanted to tell you a little bit more about Care Partners, because I understand some of you all may have come to know about this workshop in different ways. And so I want to make sure you have resources and information so that we can support you along your caregiving journey. And then after that, we will hear from our sponsors at AARP, who sponsored our education, this education program, and along with several others, we'll hear from Eddie. And then after that, we will hear from Angela. Just a few housekeeping tips. If you have a question, you can put it in the chat. Angela typically monitors the chat, and so we can answer it live on the spot. And I will also be monitoring it. And if we miss your question, we will answer it at the end of the presentation. So we will go ahead and get started. And I'm assuming, can everybody hear me, see my screen? If I can get a thumbs up from either Angela or Eddie. Okay, perfect. Thank you. Okay, so next slide. Let's see. It's always a delay. There we go. So this just gives you a little bit more information about Care Partners. So in addition to our caregiver education programs, we also we have a Dementia Day Center, which is an activity program for those that have dementia. And then our other activity program is our Gathering Place. We are located in the Houston area. So I know some of you all may be in different parts of Texas or different parts of the country, but we are in Houston. However, if you're needing some specific resources for your area, you can still reach out to us and receive support through our caregiver consultation program. And that could be done over the phone. We also have our support groups. So if you're looking to connect with other family caregivers and get more personal support from others that are experiencing caregiving just like you can join our support group. We have an online support group that meets every Tuesday at 10 a.m. So I invite you to reach out to me. I think you have our contact information in the email, the reminders, and then we'll also be sending out some follow-up emails to you all with the recording and some additional information. So I'm going to pass it over to Eddie so he can share a little bit more about AARP, and we're so grateful for our partnership with you all. So Eddie, you can take it away.
Let me say that AARP is always very pleased to partner with Care Partners. Ariel, you do a great job of supporting our membership. And in general, let me just say that AARP is a very nonprofit, nonpartisan social mission organization with a membership. We believe in helping everyone, 50 plus, and even our siblings, to live our best life as we choose to live it. That means, and I will speak personally, I'm a caregiver for my aunt and my mother. And there are times when I need to learn how to relax, to become mindful. AARP offers Mindful Mondays. We have physical activities. If you believe in wanting to cook differently or better, then AARP also has information online and live interviews to where you can actually have cooking ventures. We do physical activities, Zumba. At the same time, we have a very special interest now in male caregiving. As a male caregiver, I realize that men do things differently. We don't always seek out resources as well as other people do. We don't always know how to ask for help as other people do. We tend to believe that we can solve a problem. In my case, dealing with a loved one with Alzheimer's, that's not a problem I'm going to solve. I have some relationships, in fact, with one particular guy through AARP's last presentation, Ariel, with this project, who sought me out. I speak to him about 3 times a week. We've never met. His wife has early onset Alzheimer's. He wants to take advantage of what AARP is doing. He has the financial resources to help his wife. He knows the science about the brain and what's happening. He just simply needs someone to talk with, because he describes himself as not a very patient person. He describes his wife as one of the smartest people he's ever known. So AARP is always here as you're aging And as we're going to talk about today in this series, getting the paperwork done, the proper documents, all of this is very helpful to those of us who are caregivers. And let me say before I turn it back over to you, Ariel, that former First Lady Rosalind Carter stated it very well. There are only 4 kinds of people in the world: those who have been caregivers, those who are currently caregivers, those who will be caregivers, and those who will receive care. So this program, what you're doing, is helpful to all of us, even if we don't realize that it's helpful to us. I make sure that my young adult children are beginning to have conversations with us as adults. I'm making sure that my grandson understands that he too is a caregiver. When he's with his loved ones, when he's visiting with me, I've watched him nurture. I've watched him be a caregiver. AARP helps us as elder to make sure that we are enforcing strategies that will help our younger generation. So as you listen to the program today, know that what we're learning, our young adolescents need to learn it as well. They need to know where information is. They need to know how to get it, but they can't get it and don't know it until we can do what Angela's about to let us know. So Angela, good luck to you, and Ariel, back to you.
Thank you, Eddie. That is a perfect segue. And it's so important. I think when people think of essential estate planning in general, they think of it as something that you do when you're of a certain age, but it is in fact for all of us to take part in, and to also be aware of when our loved ones do have these documents prepared, for us to know a little bit more about it, and for us to get those documents. And I will say, I know firsthand that I need to have these documents and I don't. And so it's always important. And I've heard this presentation probably, I don't even know how many times, at least, let's say 10, Angela, if probably more than that. But it is very important for us to get the information and take action. And so Angela is going to do just that. She is a great supporter of Care Partners and does a lot of wonderful work, and very personable, very, very knowledgeable. So Angela, I'm going to turn it over to you. You should have the capability to share your screen, and let me know if you have any questions or if you need anything, and I'll be here.
It says that host disabled participant screen sharing.
Oh, you should be a panelist. Hold on, let's see. I'm gonna just make you a co-host. There we go.
Okay.
Work.
Hello, everybody. Well, we're getting this sorted out. My name's Angela Odensky, and I am a certified elder law attorney. My primary office is in Houston, Texas, but I do serve all of Texas. I can answer questions for all of Texas. If you are visiting us from outside of Texas, welcome. Some of the information that I have is applicable no matter where you are. Some of the details are going to be only applicable in Texas, so be careful with that. If you hear something from me and you're not actively in Texas and you're not doing your planning in Texas, then I highly recommend that you seek out competent counsel in your own area to make sure that the information is still the same there as well. All right, I now have screen sharing capabilities, so I am going to put my screen up. Does everybody see my screen where it says the Law Office of Angela Odensky? Fantastic. Okay, so essential estate planning documents. I cannot stress how correct both Eddie and Ariel are, that it is really important to have these documents. Now, when we talk about them being essential documents, they are good. Honestly, I do planning for families who have like children going off to college. I will make sure that those college age kids have some of these documents done, because in an emergency, you really need to have somebody who is named to be able to step in and take care of things. Because the moment you turn 18, the moment your kids turn 18, they are full-fledged adults as far as the law is concerned. And so these are documents that you need from the time you become an adult, and you need to review them over the course of your lifetime, and you need to have them all the way up and through your entire aging process. And at different points in time, you're going to make changes to them, and that's okay. Estate planning is not one and done. It is an ongoing, changing creation of documents, right? Because your life is ongoing and changing all the time. So let's go ahead and get into the meat of this. There we go. So estate planning essentially is about control, right? How much can you control and for how long? It's about control over your legacy, control over the decisions that you make, over who gets to make those decisions for you. If you have a savings account, if you own a car, if you have a house, you need some kind of estate plan. An estate plan is a big, broad kind of category, right? It can mean all sorts of things depending on what your circumstances are. It's not about tax planning, right? A lot of people think that estate means that you have a whole lot, like you own a whole lot, you have this sort of generated wealth that requires you to have estate planning. It is not like having an estate with like a bunch of land and a huge house, right? Estate planning is just, what do you have? Everyone has things. And the estate tax exemption right now, the federal estate tax exemption right now is 13.61 million per individual, which means with the unlimited marital deduction, that's 27 million per couple. I can speak from experience when I say that I don't generally do estate tax planning for my clients. Most of my clients simply do not have the kind of wealth in their estates that would require this kind of tax planning. And Texas does not have a state estate tax. So if you're visiting us from a different state with a state estate tax, then these numbers are not entirely correct for you. Now that current exemption of 13.61 million per individual is going to sunset in January of 26, and it's going to go down to 6 to 7 million per individual, and then double that for a married couple. I give you all these numbers just to make it very clear that dealing with your estate and getting your estate planning done isn't about protecting your assets from taxes for the most part, because estate taxes are not a thing for most people. Most people just simply do not have these kinds of assets. So why do people avoid estate planning, right? It's so important. And Ariel just said she's heard this exact talk probably 10 to 15 times and she still hasn't gotten it done. She knows exactly how important it is, but why do people avoid it? They're intimidated by the process, right? They don't want to think about it. They don't think their estate's big enough, right? Like we were talking about, this idea that you have to own a whole bunch of stuff to get documents in order, which is just not true at all. I think it's too time consuming or too expensive. Well, let me tell you, if you don't get it done, it's going to be even more time consuming and far more expensive for your family to have to deal with it when you don't have the right documents in place. People don't want to talk to strangers about their family or their money. Well, I hate to be the one to tell you this, but if you don't talk to a stranger about it now, then strangers are going to be digging through it later, right? You have control. Estate planning is about control. Control who you talk to, control how it works. If you don't get it done early, then you end up in a situation where you might lose control of how everything is managed. And then people don't want to think about their mortality, right? So I think one of my favorite stories is when people come into my office and they sit around my big table and they start talking to me. They're like, well, you know what? If I die, and I have to stop them right there, because this is not if. There's no if I die. None of us get out of this alive, right? When you die, what do you want to have happen? How do you want this to work, right? People don't want to think about their mortality, but I guarantee you getting it done, getting it signed, having everything all formalized gives you the ability to put those papers in a drawer and forget about them and then sleep at night and not have to think about it anymore. So we have to do the hard stuff for a short period of time to get the documents in place, and then we don't have to think about it again. It's uncomfortable, but necessary. So this is kind of like, if you're going to take a picture, I mean, I'll make sure that Ariel has a copy of the slides for everyone later on. We always give them out so that people can kind of refer to them. But if you're taking pictures or if you're taking notes or if you want to highlight or star this is the slide to highlight or star, right? So this is the list of documents that everyone should have in their arsenal, in their toolbox of documents. So you should have a will and or a trust. Now, there's differences between wills and trusts, which we can get into a little bit later, but those are the essential, that's kind of the essential like document about what happens to your stuff when you die. If you are relying on a will, it goes through probate, which means a judge has to determine that that will is indeed a valid will. If you are relying on a trust of some kind, a standalone living trust, then it does not have to go through probate. Your trustee just follows your instructions. There are good reasons to have either, depending on your circumstances. But that's the primary one for like how to deal with your stuff when you die. The durable power of attorney is the most important document you can have while you're alive. To my mind, it's more important even than having a will, because while it's more expensive, I can still deal with your stuff when you're gone if you don't have a will. If you don't have a durable power of attorney or somebody named to manage your financial affairs as you age, when you become, or if you become incapacitated, then we don't have a lot of choice except having you deemed incapacitated by a court of law and then have a guardian placed over you. And then it's onerous for your family, friends, everybody to deal with that and to be able to manage that. So your durable power of attorney is, if you do nothing else, if this is the only thing you get out of this presentation, it's get a statutory durable power of attorney. Your medical power of attorney allows you to choose who's going to make medical decisions. HIPAA authorization allow you to name people that you want to be able to talk to your doctors. And I'm going to talk about all of these documents in detail as we go. Physician's directive, designation of guardian, and appointment of agent for disposition of remains. We have a document for everything, including how to plan and pay for your funeral, or rather who gets to plan and pay for your funeral if you don't do it up front, right? Again, all of these documents are about control. How much control do you want to have? Some people are like, I don't care, I'll be dead. That's fair enough. And some people have their like service planned out down to the music and how they want the music played and when they want it played and the order of processional, right? Like this is, it's up to you. It's all about your goals. And these documents allow you to meet your goals. So the two primary elements of your estate plan, your people and your things. Like, let's take the myth out of this, right? We don't have to be all that much more complicated. Who are your people? Who are you relying on to carry out your estate plan? And who are you wanting to give your estate to? And then your things. What is your estate? When I say estate, I mean your things, right? The stuff that you have that you're passing on to the next generation, to a charity, to a spouse, to nieces, nephews, whomever, right? That is your estate. What are you giving? And so your estate plan can be boiled down to these two ideas. Who are your people and what are your things? And then how do we manage all of that? So a will is just instructions for your people about how to manage your things, right? That's it. It's as simple as that. It's generally going to be anything. So in Texas, where there are probate assets. So assets that if you have a will have to go through probate. And then there are assets that are not probate assets. So they don't pass because you're taking the will to the judge, right? They pass because like your IRA and your life insurance policy, they might have beneficiary designations, right? Pay on death designation, transfer on death designation, all of those things are going to pass automatically when you die because you've named somebody as that beneficiary. So your will doesn't have anything to do with your beneficiary designations. That's a really important point because a lot of time people have that question of, well, you know, I have my beneficiaries named, but I didn't put it in my will. Is that okay? Sure. Your beneficiaries are going to control, like whatever you wrote in that document, that's going to control. Even if you have something different in your will has nothing to do with it. So your will is going to be controlling all of those assets that don't have a beneficiary designation. So your house, your car, if you have a bank account that doesn't have a beneficiary designation, those sorts of things. Which is why when you're creating a will, it's really important to understand what you own, how you own it, who you own it with, what are their rights to it, right? And then, you know, how do you want it to pass? Like, what do you want to have happen to it? Where do you want it to go? Community or separate property is it's a big issue in Texas. Of course, we're a community property state. So is what you have, is it community or separate property? How do you know? I know a lot of people think that if they just keep all their stuff separate and they don't commingle it, but they have it all in separate accounts, then that's separate property. But that's not legally the case, right? You have to actually have signed a document stating your intent for those accounts to be separate property. If you just have things in your own name, it doesn't necessarily mean that it's separate property as far as the state of Texas is concerned, as far as the family law is concerned. If your spouse has predeceased you, did you go through probate in their estate? This has occurred. This has happened a lot when I have somebody who their spouse died, their accounts were all right of survivorship, so the surviving spouse just continued living life. They got through it. They continued on. They paid their taxes. They had access to all the accounts. Everything was beneficiary designated. Everything just went automatically to the spouse, except the house, right? Because just because you own a house together as a married couple in Texas, it doesn't mean that the surviving spouse will automatically become the sole owner of the house. Because in Texas, we own this community property 50-50, which means that when one spouse dies, the surviving spouse owns their 50%, and the deceased spouse's estate owns 50%. And so if you don't do something to transfer the deceased spouse's assets to the surviving spouse, then that's kind of lingering out there when we go to handle the estate of the surviving spouse when they pass as well. So it's really important to know, has everything been taken care of? Has all the things been filed that need to be filed? Now, maybe there wasn't a need to probate because there were other things, right? There were other things in place, a transfer on death deed or something. And so there was no need to probate because it passed automatically through those. That's great. I love that. But we need to confirm and make sure that everything is in order so that when we're working on an estate plan for someone who has a spouse who died previously, that we know exactly what we're passing and we know exactly what the surviving spouse owns. All right. And then who is your executor going to be? Who is going to be the person that you are relying on to hire the probate attorney, to collect all the assets, to pay all your debts, and then ultimately distribute everything to your beneficiaries? That's what their job is going to be. And I know a lot of people, like when you're younger and you first have your kids, you name your executor and they're probably your siblings, right? They're people of your generation. As you get older, they're getting older, which means that if you're looking at your estate plan that you drafted 40 years ago when your kids were still minors, maybe we need to update that, right? Like maybe we need to look at that and see if there's some changes that need to be made because the people that you had named to take over and manage your estate, they're the same age or older than you are. And so we might need to add some new people and bring in some younger generations to help out with that. Okay, giving your things to your people at death. There are so many ways to do this, depending on, and when I said earlier that estate plan is a broad term, this is kind of what I meant, right? Having an estate plan means having your documents in order, having a will in order, doing all of that, but it also means making sure beneficiary designations are the way that you want them, making sure that you have everything set up the way that you want it to be set up if we can pass things pretty easily. So there's 3 ways that things go to your people. Either you have a beneficiary designation, right? You have a will or a trust that says where it's going to go, or it passes to whoever is in line as according to the state of Texas. When you don't have a will, when you don't have beneficiary designations, when you haven't taken care of any of this, the state of Texas has a statutory list of people who get your stuff. That may or may not be the same list of people that you wanted to have your stuff. But if you wanted to control that, then you had to set up these documents before that happened, right? All right. So we talked a little bit about the things that pass to people outside of a will. I don't, for some reason, I don't think I have access to, or the way I have my screen set up right now, I don't have access if questions are coming in. So Ariel, if you will kind of keep an eye on those questions, because if there are some coming in, I'm not seeing them yet, but that's okay. I will get to all of them if there are any.
Yeah, I'm not seeing any either, Angela, so you're good to go.
Perfect. Okay, so things that go to people outside of your will. Right of survivorship automatically passes to the other person who owns that property, whatever it is. The most common right of survivorship that we run into is when spouses own a checking account or savings account together, right? When a spouse owns an account with another spouse, generally speaking, there's going to be a right of survivorship on that account. And what that means is that when one spouse dies, the other spouse automatically takes over that account and continues using it. The bank's not going to freeze the account. There's no need to have a stop in anything because both account holders had 100% access to that account at all times. And when one died, it just automatically became the other one's account to continue using. So we run into that a lot in spousal situations. The other time that we run into that is when we have an adult child caregiver who is helping one of the parents manage their estate, right? There might be a joint checking account so that the adult child can write checks and make sure that everything's taken care of for their parent. And oftentimes when those accounts are set up, the bank will automatically make it a right of survivorship. So if that is the situation that you're in, I highly recommend that you contact the bank just to see, right? You want to know for a fact if that account belongs to you upon the death of the person that you're caregiving for. Or if it's just as a signer relationship, right? So sometimes you'll just be named as a signer on that account, which means that you don't have any right to it upon death. You don't have any legal right to it at all. And sometimes it's named in joint ownership with right of survivorship, which means you do have a legal right to it and it will pass to you upon death. Knowing that is really helpful because a lot of people don't realize when they name an adult child as a joint owner on an account that it has a right of survivorship, that child just becomes the owner of it by law upon the death of the parent. And so if the parent wanted to say have that account split amongst all of their kids and not just their caregiver kid, we can run into some issues. Sometimes the adult caregiver who's been on the account refuses to share it, and they don't have to by law. But sometimes they want to share it, and depending on the size of the account, they run into issues where they have to file gift tax returns because now they're having to gift their money to their siblings. It doesn't mean they owe gift taxes. It just means they have to go to an accountant, and it's an additional thing that they have to deal with in order to make sure that happens. And so it's kind of like no good deed goes unpunished, right? This idea that, you make it easier. Everyone wants to make it easier so that the caregiver can take care of things. And I'm all for that, but we need to know what the ramifications of that are and exactly how that's going to work and what that means in practice. When the loved one, the person being cared for, does die. Beneficiary designations automatically pass to named beneficiaries, life insurance, retirement accounts, etc. And like I said, if you name in your will, I want my retirement account to go to Susie, but on your retirement account, you said the beneficiary is Joe, Joe gets it. Your will does not control it. So if you have a beneficiary named on a retirement account or a life insurance or anything else, that's where it's going to go. So it's really important when you're reviewing your estate plan, when you're looking it over now, it's very important to also review all of your beneficiary designations. Where's everything going? All right, so what is a valid will in Texas? A valid will in Texas is actually fairly easy to accomplish. The person has to have capacity. Capacity to create a will is a fairly low bar. So just because a person has a diagnosis of dementia or a diagnosis of some kind of incapacity, that does not mean that they are legally incompetent to sign a will. Until a judge deems a person legally incompetent and determines that they need a guardianship, then technically by law, they are not legally incompetent. And so even if a doctor has signed a note that says they can't manage their financial affairs, right? That's kind of a global understanding. But that doesn't mean that they can't necessarily sign a will, because managed financial affairs is like investing in the stock market, right? They can't do that anymore. But do they know what they own? Do they know who their kids are? Do they know that they want to leave their stuff to their kids when they die? Do they understand that a will accomplishes that goal of leaving their stuff to their kids when they die? If they can hold those four thoughts in their head at the same time while they sign a document, then they have legal capacity to sign a will. It doesn't matter what their diagnosis is, right? So it's just because somebody has been deemed, has fallen on the medical spectrum of incapacity, right? So we have to look at it that way. So incapacity for medical purposes is a spectrum. You have some capacity, you may have lost some capacity, you have lost a lot of capacity, you're completely incapacitated, right? So there's all these sort of lines that you can go through for on a medical spectrum. When it comes to legal capacity, you either have it or you don't. It's a light switch. And so, you know, just because somebody falls on the medical spectrum doesn't mean that they are legally incapacitated. And so it's really helpful to talk to a certified elder law attorney before determining that someone is no longer able to manage their own affairs and take control of some of these documents, right? And that's also true for some of the other documents we're going to talk about. But so that's they have to have legal capacity, be over 18. They have to understand what they're doing, what effect it will have, what they own, who their heirs are, and they have to be able to choose what they want, right? If they can do all of those things, then they can sign a will. And the will cannot have been tampered with. So we see this a lot, right? Matter of fact, I dealt with this with one, and a gentleman got divorced. And rather than creating a new will, he used whiteout to white out his previous wife's name. That does not work. You cannot do that. Any changes made to a will have to be executed with all the same pomp and circumstance that the will has to be executed with. So generally speaking, like if your executor has died and you want to name a new executor, you can't just mark out that executor's name and then write in a new executor's name and initial it. That change will not be valid, right? So if you need to make changes, you need to go to an attorney and have those changes officially made. So there's two ways to write a valid will. It can be typed, signed, attested by witnesses. The witnesses are expected to testify unless there's something called a self-proving affidavit attached to the will. The self-proving affidavit is par for the course for any attorney that's doing your will for you. So if you've gone to an attorney and you are creating it, there will be a self-proving affidavit attached. Or a will can be entirely in your own handwriting and signed. I don't recommend this. When you do a will in your own handwriting, that means that you have to have witnesses who can testify that that's your handwriting. I don't know about y'all, but it's been a while since I've handwritten a letter, right? Like finding handwriting witnesses is difficult. It's not impossible, but it is difficult. And so I do not recommend doing that. Plus, you know, you don't know what you don't know as far as like the language that needs to go into it. But I have had a colleague that was able to probate a Christmas card as a will because there was enough intent in it to show that they wanted this person to have this thing, right? So it's possible It's just harder on your family when you do things like that. So go to an attorney, have the will done properly. Why shouldn't I just create my own will? Okay, let's talk about that. It's easy to create problems in both time and money for your family when you create your own will. And again, it's because you don't know what you don't know when it comes to like the specific language that's required in a will or that's beneficial in a will. Maybe not required, but beneficial. Examples that have arisen. Minors being able to access their inheritance because it was put in a special kind of trust account, and then no custodian was over it, and then there was no way to name a custodian. And so we kind of had to sort it out. But that was an avoidable issue if the person had just gone to an attorney and had everything sorted out and had all the questions answered, right? Making an heir lose government benefits. This is a big one, right? So if you have a loved one who is on government benefits, supplemental security income or Medicaid benefits, and they inadvertently inherit from you for whatever reason, then their benefits could be jeopardized. Or if you are just trying to be generous and you want to, you know, they need it, and so you leave something to them. If you do that, then you could jeopardize their benefits. It's really important that you have an attorney kind of go over all these different aspects of your family and who might inherit at some point in time in order to make sure that you don't inadvertently jeopardize someone's ability to get the care that they need because you generously gave them something, right? Trying to give away money that wasn't technically theirs, so they didn't realize it. Again, that separate community property thing. Married couples truly believing that they had separate property because they kept them in separate accounts with separate names on them, but they didn't actually officially sign any documents saying that it meant to be separate property. And so, you know, one of the spouses is like, oh, I don't want my husband to have any of this. I want it all to go to my kids. And it's like, well, half of that's community property. She didn't believe me because they'd kept it separate. Well, that's not enough, right? So it is community property, but on the other hand, the husband's accounts were also community property. So there's that, but you have to know how you own things. And you have to know, like, legally how you own them in order to make sure that you're giving away, that what you're giving away is proper. And then, of course, no living witnesses to testify as to handwriting. That's the hardest one, I think, is making sure that we have people that can testify as to handwriting when we have a handwritten will. And there are these, you know, there are all these like forms and things that you can fill out online. And for the most part, you know, I can't say for certain whether or not it's going to be right for you. Somebody with the simplest of circumstances might be fine, might be able to get away with something like that. But again, I think everything comes down to you don't know what you don't know. And so having competent legal advice is really important in getting these documents done. All right. Should your will include a trust? Should there be an additional trust created by your will? If you have minor children, absolutely. There should be a trust in there for them. Are you leaving money to a person with disability or a person that's on government benefits? Yes, there should be a trust created in that will for them to make sure that there's no risk of those public benefits. Do you have special wishes, right? Do you want to attach strings? Because a will gives all your stuff. If you just leave your stuff to a person in a will, there are no strings attached. They get it outright. If you want to attach strings, like you want it to be for education purposes only, or you want it to be used to purchase a house or be used for a specific thing, then you have to say that and you have to put it in a trust for that. Do you want to leave funds to care for your pets, right? Pets are family too. Making plans for your pets to make sure that they're cared for if something happens to you is really important. And so Texas has a statute on the books that says that we can create trusts to care for our pets. And I do that often, actually. I quite often create circumstances where a pet is going to be cared for. We can name a caretaker, we name a trustee, we put a little bit of money in there so that like vet bills and food bills and things are paid, so that the person that you've given your pet to, the caretaker of the pet, isn't sort of burdened with the extra cost of maintaining and loving that pet. All right, the probate process is wrapping up the estate. Okay, so probate in and of itself, when you enter a will into probate, basically what that means is that a judge looks at the will and says, yep, this is a valid will. Yep, this person who's named to serve is qualified to serve. Excellent. That's what it means to go through probate, to like have the will entered into probate. And then everything else is just the administration, right? Everything else is wrapping up the estate. It's determining that what the person owned, putting it all in one spot, figuring out who all the debtors, figuring out what all the debts are, who all the creditors are, what all the debts are owed, valid debts only, right? And then distributing it out to the beneficiaries. So that's what probate is. In some cases, the probate process is very simple. It takes a few weeks. We can get in and out because it's not a big deal. We're just passing a house and a bank account, right? Sometimes the probate process is significantly longer, just because it might take longer to collect all the assets, to have everything ready to go. And to pay all the debts, to know where what all needs to be paid out. So it's every time is going to depend on the circumstances as to, how long the probate process is going to take and how difficult it's going to be for the family. And going through the probate process can prevent some unscrupulous credit scams, and not just scams. That's one way of putting it, because there are certainly people out there that will send bills that are not valid bills when they know that someone has died, in the hopes that the executor just pays it, right? That has happened. But I've also had circumstances where I've had an estate that had a collection agency try to collect on a medical bill, and then I got the same bill from the hospital, and then it turned out that Medicare had actually already paid it. Right. And so it was just a case of the left hand and the right hand not knowing what each other was doing, and then Medicare coming out of nowhere and just taking care of it. But the executor still got these bills and was needing to know what to do with them. And so we had to verify that they were valid debt. And it turns out they were not valid debt. But that's part of the executor's job. And so when you're naming an executor, when you're naming a person to manage this, you have to think about who is going to be the person who's best situated to kind of make those sorts of judgment calls and to follow up on those kinds of things. Okay, so now let's talk about your power of attorney. I said it once, I'm going to say it multiple times before this presentation is done. Your durable power of attorney is the most important document you can have while you're alive. It's you choosing someone to make financial decisions for you when you are not able to make them for yourself. That's dealing with your life insurance. That's dealing with your retirement accounts. That's somebody who's going to deal with Social Security and taxes, and you're naming somebody who you trust to manage the day-to-day existence of your financial life when you are not able to do it. You're choosing somebody who's going to use your money for your best benefit and not theirs. It is enormous power that you give somebody with a durable power of attorney document. It is the most abused document that we have. People use it for nefarious purposes all the time. But it's also the most important document. And so it's really important that you name people that you trust, and you name multiple people, like as successors, not together. I don't like co-agents, but as successor agents, because then they can kind of like watch over each other, right? A well-drafted power of attorney can alleviate the need for a guardianship. So earlier we talked a little bit about guardianship. What it means in practice is if you don't have a durable power of attorney, or if your loved one doesn't have a durable power of attorney, and you're not a co-signer or a co-owner on a bank account, or there's a retirement account involved, or there's any asset at all where no one else is named as an owner. If you don't have a durable power of attorney, then the only way we can manage that asset is to go to court, have the person, when they can't manage it themselves, go to court, have the person deemed incapacitated by a court of law, have a guardian named, and then that guardian is subject to court review every year. They have to file an accounting where they have to account for every penny that was spent, that has been spent on the person, and it has to balance out to zero. It is expensive and it is onerous, and we only do it when there are literally no other possible options to protect a person and their funds. So it is it's a big deal. Having this power of attorney can help alleviate the need for going through all of that. What happens if the power of attorney is listed as well as an appointed guardian? So that's one of the documents we're going to talk about. So a guardian isn't a guardian until a judge says so. An agent under a power of attorney is an agent as soon as the document is signed and notarized. Okay. An agent cannot veto the principal. They don't have any additional control over the principal. They don't get to tell the principal what to do. An agent has to act on behalf of the principal only. A guardian is a legal relationship. And so there's a lot more, there's just a lot more to it. And you can name a person that you would like to be your guardian. Now that person still has to go to court. That person still has to be named. That person still has to pass the background checks. But you can control who your guardian is by saying who you want to be your guardian, and more importantly, who you don't want to be your guardian. You can exclude people that you don't trust to manage your stuff. So here's a good question. The chat box is the questions in the Q&A are coming up. So I'm going to stop for a few seconds and answer some of these questions because they're good. Regarding successor agents, powers of attorneys, 2 adult daughters, 1 here in Texas, 1 in New York. Is it better to name the Texas daughter as the agent and the New York daughter as successor? I don't know. It depends on your daughters, right? Who they are. We live in a global world, right? I definitely have families where the person in Texas is not as suited to act under the power of attorney because it's not their skill set. Whereas the child who lives in New Mexico and works for a bank has the skill set, and so is better suited to be able to manage the financial affairs. Proximity is not the most important thing when it comes to naming an agent under durable power of attorney, but rather who has the ability to do the best by your finances, and who has the ability to take on the burden. Because sometimes being an agent under a power of attorney is a full-time job. And so when you're choosing who your agents are, it's important to think about the person themselves and not necessarily rely on where they're located, right? That's to a lesser extent. Now, if the person in New York travels all the time and they're never going to be around, then they're not necessarily a good fit because they wouldn't necessarily be there to take care of things in the moment. So those are kinds of considerations that you have to think about. There's no one size fits all answer to this question. So my mom signed a specific power of attorney from HIPAA. Do we also need a durable power of attorney? So a HIPAA authorization is just an information gathering document for medical records. It has nothing to do with financial at all. In Texas, we do not have a combined financial and medical power of attorney document. If you have medical already done, that does not mean someone can manage your financial affairs. You have to have both the financial power of attorney, which is statutory durable power of attorney, and the medical power of attorney, HIPAA authorization, etc. All of the documents are kind of separate that way. You cannot take a medical power of attorney to the bank. They will not accept it. You can't take a financial power of attorney to a doctor, right? So we have to have those separate documents. Which is a good question because some states do have those kinds of combined documents. You can just name an agent to manage all of your financial and medical affairs. We don't have that here. All right, so your medical power of attorney, you choose the person who's going to make the medical decision that you would make if you were awake, aware, and able to make that medical decision for yourself. Okay. This is not about who's going to choose what's in your best interest. It's about who knows you so well that when the doctor comes to them and says, I need you to make a choice, they can say, well, this is what I think that they would want. And this is the decision because that's what they would want, right? If no agent exists, then Texas law has a statutory list of people who will be named as the who will be able to make those decisions. So of course, if you're married and you don't have this document, then your spouse is able to make the decision. If you're not married, but you have kids, then it's, the majority of the reasonably available children to come in and do it and on the way down. If you don't have a lot of family, then you have to choose somebody, right? It's hard to, you just have to choose somebody. You've got to find somebody, friends, etc. And make sure your agent knows your wishes. Have the hard conversations. And they are hard because they're about medical, like treatment and end of life treatment and what you want and how you want to be treated at the end of life. These are difficult discussions, but they are really important because your agent is going to be there and not be able to communicate with you about what you want. And then they're going to have to agonize over what you want if you haven't had these conversations, right? HIPAA authorization is your eyes and ears. It's not a decision-making document. It is purely an information gathering document. And so, for example, if you've named your spouse as as a HIPAA authorization, it means that the doctor's office can contact your spouse and let them know about test results or whatever. Also, if somebody calls if you're in the hospital and a family member calls, if they're not authorized, then the hospital technically couldn't even tell them that you're there. And so it depends again on your family circumstances, on your situation as to who you want to have authorized to receive this information. But it is purely just medical information. It's information gathering and not decision making. So this is the designation of guardianship prior to need. We were talking about this a little bit earlier, where you can designate a person that you trust to be your guardian. So there's two kinds of guardians: a guardian of the person, which is the one that decides where you live, who your doctors are, etc., and a guardian of the estate, which is the person who manages all of your money, right? You can choose in this document who you want to be named as the guardian of the person and the guardian of the estate. And again, you can name the people that you don't want to have any ability to make those decisions for you. As long as they are qualified and not disqualified by law, then the court will take into account what your preferences are. They do still have to go through the process though, right? Like having a designation of guardian prior to need doesn't get triggered by anything that happens outside of a courtroom, because only a judge can deem somebody incapacitated. So again, if you have a doctor's note that says this person's incapacitated, that does not automatically trigger this guardianship relationship. It is a legal relationship and you have to go to court. And hopefully we want to avoid that altogether, because you have a power of attorney with robust enough powers and you've named a person that is trustworthy enough, that's taking care of business for you, that we don't have to go to court. We can put this document in the drawer and never pull it out. Like, that's the hope. We have it in case we need it, but we leave it alone under most circumstances. Your living will, physician's directive. This is the document that says how you want to be treated end of life. If you are in a situation that's deemed terminal, meaning you're not going to live longer than 6 months, no matter what medical interventions the doctors use, or your condition is considered incurable, meaning that they've done everything they possibly can and you're not going to get any better, then you can decide in this document, if you are unable to communicate at that time, then this document can communicate for you whether you want to be kept alive on artificial life support. It is not an incredibly robust medical directive, but it's what we have. And it gives you an opportunity to make some decisions. And as important, it gives your family something where they know what you wanted. And it gives them a little bit of ammunition to advocate on your behalf for what you want. And so having that document done is really important. Some people don't want it. Some people don't want to make that decision themselves. They want their agent under the medical power of attorney to make that decision for them. They want someone who's on the ground talking to the doctors to make that decision for them. That's as valid as anything else. You don't have to sign this document. It's just helpful so that your family's not wondering. And then appointment of agent for disposition of remains. It's the person that's going to arrange and pay for your funeral. We have a document for everything. This one still cracks me up. If you can add special instructions, you can tell them what you want. If you want to be cremated, you can tell them where you want your ashes spread or whatever. And if you engage in pre-planning, which I'm a big fan of, if you pre-plan your funeral, then your family basically calls a number and gives an insurance policy number, and then it's all sort of taken care of. And I've never had a client in my office whose parent had done that for them that wasn't eternally grateful that they just didn't have to deal with it. So I'm a big fan of pre-planning. You can go to any funeral home or whatever to talk to them about that, but it's one of the kindest things you can do for your family. Pre-planning your funeral and take care of your long-term care, right? If you don't have it done, that's fine, but still naming a person is really helpful, especially in blended family situations, because, inevitably I get this call, right? So spouse wants to bury dad in their family plot, and adult children are like, no, dad wanted to be buried in this other place. Who gets to make that decision? And so my first question is, do they have an appointment of agent for disposition of remains? And when that answer is yes, then I'm like, whoever that person is named, that's who gets to make the decision, right? So there's no question. Again, if you pre-plan it, then it's already taken care of. All right, so what happens if you don't plan? If you don't get all these documents in place, you lose the ability to control things. Like this is your control. Right now you have control, and you can make decisions, and this is how you maintain that control. Your ability to make decisions regarding property and legacy. When you don't have the documents, if you haven't planned, probate could be a far more time-consuming and expensive. There might be pitfalls that you never knew about if you didn't actually engage with somebody to kind of go over all of your stuff, like the right of survivorship issue, where you leave everything. Because so I had a client whose mom, he was on his account with his mom as a right of survivorship. The account had about $400,000 in it when she died, and he had 3 siblings and they were all going to split it equally. And he's super happy to split it equally. Like, this was not a case where we had a rogue adult child. He wanted nothing more than to make sure that everything was done exactly the way his mom wanted. But then we had to go to his accountant and the financial advisor and be like, okay, we got to file all of these different 706 gift tax returns because it's now his money that he's giving away to his siblings. Like I said, it didn't cause any specific tax consequences for him. He didn't have to pay anything. He just had to deal with it. And that wasn't something that he ever thought was going to be an issue, because it's just, that's what she wanted. And so he was just going to do what she wanted. Right. And if you don't have a properly planned estate, then your stuff goes wherever Texas law says it goes, whether you want it to go there or not. All right, so that's my essential estate planning documents. Those are all the documents that you need. Here's my information. I am in Bel Air, Houston, Texas, but I do planning and stuff for everybody all over the state, just because it's, Zoom is an amazing thing. I will stop sharing my screen, and if there are additional questions, I'm happy to answer them.
Thank you so much, Angela. This is great. Thank you. I don't see any questions in the chat, but we'll give it a minute for you all to type your questions. Also, if you would like to unmute yourself, just raise your hand and I will unmute you so that you can ask your question live. Give me another second.
No, fantastic.
Another question.
It was enough. I gave all the information.
Yes, so if you all have any additional questions, please feel free to reach out to Angela. And we will be sharing this presentation. Oh, we have somebody that's raised their hand. Let's see. I'm going to unmute you. There you go. Mary, you can unmute yourself and ask your question. Mary, you're muted.
Okay,
Oh, there you
hear
go.
me?
You're
Yes,
unmuted.
thank you. Okay, this was a great presentation. Thank you so much. I was just wondering, with these documents, what happens if you have a parent who moves to live with you in Texas, but the document was signed in another state, for example, like Louisiana? I mean, do the documents still transfer over effectively or successfully, or do we need to do more, redo the documents, like power of attorney, for example, living will, so forth?
So that is a great question that I get often. My advice, generally speaking, is yes, if she is still able to sign new documents. So she still understands what she's doing. She knows who we're dealing with. If she's able to sign new documents, then I do recommend signing new documents in Texas, not because the ones that are from other state are not valid. I want to be very clear about this. It's not that they're not valid. It's that financial institutions tend to be very squirrely when you're using a power of attorney. And if they are seeing a document for the first time that they are unaware of or haven't seen before, then they could just hand it back to you and say, this isn't valid. They're not necessarily making a legal, they're not lawyers, right? They are people who are just like, they work at a bank. And so if they see something that they're unfamiliar with, the knee-jerk reaction is, oh, we can't use this. And so in order to make things as smooth as possible, I do like to redo the ones for Texas. And I do think that, generally speaking, the medical powers of attorney, so durable power of attorney, statutory durable power of attorney, those, as long as the powers listed are relevant to the state, they can be fine. It's just you might run into some issues, right? The medical powers of attorney, I also do recommend, again, having them redone, because for the most part, like Texas statute says that the medical power of attorney has to be in substantially the same form as the form that they have posted in order for it to be valid. But again, practically speaking, a doctor wants a decision maker. And if there is something that shows who the decision maker is, then generally speaking, they are going to honor it. So this is a practical question as opposed to just a strictly legal question to my mind. Legally speaking, they might be fine. Practically speaking, you might run into roadblocks.
Okay, all right. Well, thank you. Yeah, this is what I was wondering. And then one last question about the trust. I'm still, like in my mother's case, she does have a will, but it's old. And I think, an attorney a while back said it should, in her state, home state, said it should be okay, even though some things have changed. People have passed and so forth that were named on the will. But anyway, he said it should be okay. But I have heard a little bit about this trust, and I'm wondering if we need to try to do that. But she's not able to really make decisions now. So, it's, I don't know if we still can do that. I need a little more information. So, in a situation where the person is, like in my mom's case, can't make decisions about a trust, is it possible still to do that?
Well, it depends, right? I hate to give you the lawyer answer, but that's it. So a Texas durable power of attorney has a special power that an agent can, that a principal can give an agent to create a living trust for them if they're not able to create it for themselves. I don't know about Louisiana. I don't know if they have that kind of power. I don't know if that's one of the powers that's in the document that she has. And so it depends, like in terms of like creating a trust for somebody, it depends on the authority. Like there are circumstances under which an agent might be able to create a trust, but it completely depends on the document that grants them authority to do anything. So it depends on what's in that durable power of attorney as to whether or not they have the special right to create a trust for somebody. It's not a black and white kind of question. And whether she needs a trust or not, again, kind of is going to be dependent on her circumstances. So even if you did create a trust, it would not, you couldn't create a trust and change her testamentary intent, which means that if her will says everything goes to these people that have now passed, it would still need to go to their descendants. Like if you created a trust for her under your agency authority, if you have it, and you changed her testamentary intent, that's not okay. And so it's important to kind of, like in your case, if she does not have capacity to make changes or to do new things, then you have the documents that you have, and that's sometimes just how it works. And if you have questions about how those documents work, you really do need to go to an attorney and have somebody advise you on what your authority is, and what the best case scenario might be moving forward.
Okay. All right. Thank you. I appreciate it. Because, yeah, we're looking into long-term care now. So, but right. Okay, it's so complicated.
It can be very complicated. I agree. Like caring for a loved one as they get older is not for the faint of heart. And even if you think you have all the documents and everything together, sometimes little things can fall through the cracks. And so it's really, again, it's just really helpful for you to get some legal advice as far as like what you can and cannot do.
Right. Okay. Well, thank you.
You're welcome.
Thank you. And also, you mentioned Medicaid or nursing home, and I just wanted to let you all know that we will be doing another presentation in the summer, and Medicaid 101 will be covered in talking about planning for long-term care, all of that. And so that will be another presentation that Angela will be providing. And so stay tuned for that. You will probably receive that email in the next couple of months or so. Does anybody have any other questions? Well, okay. Well, thank you all so much. Angela, thank you for doing this presentation. I am going to work on getting those documents together, talk to my family. You know, when you think you're young and you have time, you just put it off.
Yep. Easy to do.
It is, but it's so important. It's so important. And thank you for sharing your knowledge and just encouragement and, you know, the nice way to encourage people to do it now. Do it while you can.
Yeah,
So,
do it while you can.
Yes, absolutely. Angela, did you have anything else that you wanted to add before we close out?
No, just to kind of, again, the plug, it's a 3-part series. I'm doing this presentation again on essential estate planning, but then I'm also doing one on like how to plan for long-term care. And then we're doing the Medicaid 101. So it's kind of the other 2 parts of this series are more how to deal with long-term care planning ahead. And then what happens if you didn't plan ahead or your parents didn't plan ahead and now we're in crisis, what do we do? So that's the next series that we're doing here in June, May, June. And so I hope everyone can join us.
And then we have one more workshop for this series. It will be in April. It's the second Thursday in April. So second Thursday in May. I'm sorry. We're in April. So it'll be May 9th. And that will be community resources. So we'll end this series just talking about general resources. So we'll have AARP, we'll have care partners, we'll have the VA, we'll have the Harris County Area Agency on Aging. So that will be a great presentation to attend if you're just wanting to learn about general resources. And then we will follow that with Angela's presentation. We'll kick off the legal and financial series. Okay. And I'm saying that I'm like, is it the series or is it Essential Estate Planning? It's the series. Yes.
It's the series.
It's the series. Yeah. Which will also cover Essential Estate Planning. So yes. So we look forward to seeing you all again. If you have any questions, please reach out to me. We will be sending out the recording as well as the slides so that you can have that for your records. Okay.
Perfect. Thank you so much for having me. I look forward to seeing you again.
Yes. Thank you, Angela. And thank you all. We'll see you all later. Enjoy the rest of your day. It's beautiful in Houston. If you're in Houston, it's a very nice day outside. So get some fresh air. Awesome. Thank y'all so much. Y'all have a great day.
Bye.
Bye.